When the lawyer and the client, when the lawyer and the business person are working with their counterparties to try to come up with a contract, one question, and a really critical question, is who controls the writing of the contract. The phrase that we use in the law is who controls the pen, which means who's going to have principal drafting responsibility for the contract. I like to keep drafting responsibility whenever I possibly can. There are certain circumstances where it's not going to be possible for me to have principal drafting responsibility. For instance, this transaction that I just concluded, my client is a firm doing a media firm in another country, and they were entering into a joint venture with a money partner, with a world famous investment and venture capital firm. And there was no way that my firm and my client were going to be able to control the deal and to control the documents when we were dealing with this international, world famous investment banking firm. So we knew in that instance we were not going to be able to control the pen. We knew that our job was going to be to try to fight to get provisions with which we were comfortable in the transaction documents, but we were going to have to accept that the documents were going to be in a form and ultimately in a structure that was more to the liking of the investment banking firm. The drafter of the contract generally has the best opportunity to shape the contract toward in a way that his or her client prefers. And that's one of the reasons why I always like to be in charge of drafting, particularly when I'm drafting documents that are not form documents. A lot of transactions that lawyers work on today, there are generally accepted forms of those types of contracts. When we're dealing with what sometimes we call bespoke documents, or documents that sort of have to be created for the particular transaction, I really want to be in charge of drafting those documents, because then I get to control the shaping of the documents, and I get to control the structure and the wording, and I get documents that I feel I generally like better, and I'm able to resist changes better if I'm in control of the documents. As was the case with my client who was entering into the joint venture with the venture capital firm, the party with most bargaining power usually is the party that drafts the documents. Sometimes that party doesn't want to take on the responsibility for drafting, but almost always the party with the greater bargaining position, the party who has the stronger hand in the negotiation, that's the party that usually controls the negotiation of the documents. It's just a fact of life. It's a fact of business practice, and we just have to come to deal with it and learn that that's the way that things are going to be. When we are drafting documents, we work very hard. I work very hard, and I hope that other lawyers, certainly the lawyers that are in my firm, I'm hoping that they're doing this, that we are trying very hard to avoid making mistakes in the drafting of documents. And there are a couple of types of mistakes that are, I don't want to say common, but there are a couple of types of mistakes that do show up from time to time in documents. The easiest of those to deal with is what we call a scrivener's error. And it's called a scrivener's error, E-R-R-O-R, not E-R-A, because in the days before typewriters, and certainly in the days before word processing and Microsoft Word and WordPerfect and Google Docs, legal contracts were drafted by hand. And they would be drafted in the final version by someone called a scrivener. And a scrivener was someone who wrote out the contract provisions. And often the person needed to know something about the law to know which particular provision to put in and how to structure the contract. But the main function of the scrivener was to write. There's a famous short story by Herman Melville called Bartleby the Scrivener, about a scrivener who works in a law firm, and some of the things that happen to this scrivener and this lawyer in the course of their dealings. When I first read that story, I had no idea what a scrivener was. This was when I was in high school. It was long before I went to law school. But that was a common profession. It was a well-respected white-collar profession at that time. I'm reading a series of novels set in the Tudor period in England, and the main character is a lawyer, and one of his chief assistants is the person who is his scrivener, and they're always solving murder mysteries and these complicated situations involving the Tudor royal family and various people that you hear about through history. But I'm always fascinated by the fact that there is this scrivener who most scriveners were sort of very maybe timid, whereas this gentleman, Jack, is not at all timid. Well, anyway, we're getting a little bit far afield. But a scrivener was the person who wrote out the contract. And a scrivener's error is what we would nowadays call a typo. It's a mistake. It's an unintentional mistake. It's where the parties agreed on one term, but the contract contains a different term. And what has to happen in those situations, if the situation does arise, the parties have to go to court. If they can't negotiate an amendment to their contract, if, for instance, they agreed on X, the contract says Y, one party tries to enforce Y, the other party will need to go to court and ask the court to reform the contract, to change the contract, to reflect what was their agreement. And the court will look at all of the available evidence. And if the court can determine from all of the available evidence that, yes, indeed, the parties did intend the contract to say what X believes that it should say, the court will reform the contract and will enforce the contract as it was agreed by X and Y, even though the writing of the contract might contain provision Y and not provision X, even though that's what the parties to the contract had agreed to. So that's what we call a scrivener's error, or just think of it as a typo. There are two other types of mistakes that often are confused. There's the concept of ambiguity, and there's the concept of vagueness. Ambiguity is accidental. Ambiguity is when parties draft a contract and accidentally leave it ambiguous. And there are multiple possible interpretations of a provision. And it's up to the court to generally sort out from the available evidence what the parties meant and to give a proper reading to the provision that is ambiguous. The general rule in a contract is that an ambiguous provision is interpreted against the interest of the party that drafted the contract. So if the party who drafted the contract included an ambiguity, and there are two interpretations, two logical and reasonable interpretations, the interpretation given will be the one that favors the party that did not create the ambiguity and will go against the party that created the ambiguity. So remember, ambiguity, accidental. Both words begin with A, because we have to distinguish ambiguity from vagueness. Vagueness is intentional. Vagueness is voluntary. So remember, vagueness, voluntary. Ambiguous, accidental. Voluntary vagueness is when the parties deliberately leave a contract provision unclear. And why would they do that? They may do that because they don't think that they can get the other party to agree to what they really want the contract to say. So they'd rather leave the provision vague so that they can possibly make an argument later on, if an issue arises, in favor of an interpretation that supports the view that they want to take of that particular provision. They also the parties may not really know what they want, and so they leave the provision vague purposefully, voluntarily, so that they can then go back and decide later on what it is that how they want to address this particular issue. So vagueness is where the parties specifically leave a provision unclear, and the intent is that later on they will give meaning and they will give some kind of substance to that particular provision. So those are the three common mistakes that we see in contracts: the scrivener's error, ambiguity, and vagueness.